Hello, everyone. Welcome back. We are now on episode 4 of the Law in Motion Saga. Today, we are going to be talking about motions for summary judgment, summary adjudication. This is a slightly more involved and detailed talk, so we're going to be going an hour and a half today, so that hopefully I won't have to really rush through all of the slides and everything that I need to talk about. As usual, I have my disclaimers. As you all know, I am a quasi-judicial employee. And although I am happy to take questions as we go through the seminar, I cannot answer questions that concern matters that are currently pending before the Contra Costa County Superior Court, and nor should anybody construe anything that I say here today as being an indication of how any judge might rule on a particular issue. And then, of course, as you all know by now, everything involving fact patterns, examples, and sample forms are purely fiction and should not be treated as something having to do with anything pending in the court. We have our abbreviations. Again, all of these materials will be sent to you when you get your attendance certificate. So when you have your materials, you'll have all the abbreviations that I use in the materials. The Law in Motion universe, again, this is our fact pattern. We're really going to be looking at our facts today when we talk about summary judgment, and really when we look at the sample forms. Basically, what we have going on here is a will contest filed by Luke Skywalker, seeking to invalidate the trust executed by his father, Darth Vader, before his death. And you have the details here for our fact pattern, the grounds for seeking an order invalidating the trust or lack of capacity and undue influence, also financial elder abuse, and anything else that might come up that would fit in our discussion regarding summary judgments and summary adjudication. So you've got all of the facts here that you can review, and you've seen them again before. And so let's move on to the substance of our talk: motions for summary judgment and summary adjudication. What I'm providing here are the major authorities that you will run into as you engage in summary judgment or summary adjudication litigation. The major statutory authority is Code of Civil Procedure, Section 437C. The rules of court are 3.1350 through 3.1354. And I've added here Aguilar versus Atlantic Richfield Company. It's a California Supreme Court case from 2001. I strongly recommend, if you are not familiar with this case, to at least become familiar with its holdings or read it through. It is a thick opinion, but it is sort of the benchmark of interpretation of CCP 437C. It gives you many of the rules that we will be discussing here in this seminar, and what you will be using in order to prosecute or defend motions for summary judgment in practice. In my humble opinion, Aguilar should be cited in each and every brief that is filed in connection with summary judgment or summary adjudication, because you'll talk about this. We'll talk about this later. Aguilar and having an understanding of its rules really conveys to the court that you are familiar with the intricacies of what is a very complicated statute. If you've ever seen CCP 437C, I think it goes to subdivision T or something like that. It is complicated, it is detailed, and if you don't follow it, you are going to end up on the short end of the stick. So the theme that we're going to be hearing throughout, and that you will see throughout in any summary judgment or summary adjudication litigation, is the concept of there being no triable issue of material fact, and that the moving party is entitled to judgment as a matter of law. That is the overarching concern that the court's going to be addressing in all summary judgment litigation. So when you talk about whether or not, when you start considering whether or not you have a case that's appropriate for just summary adjudication, you want to consider a number of pros and cons. The pros, obviously, you get to end the case early and perhaps even at a lower cost rather as compared to taking the case for trial. You'll eliminate high stakes causes of action. You would educate the opponent, and that can be a good thing, especially if you are seeking to reach a settlement of your case. It would allow the parties to really focus on discovery on what the major issues are in the case. You can educate the judge about your case. However, this really applies when you're in a court with an all-purpose judge. And on review, if your case ends up getting sent up on appeal, on review, you have an abuse of discretion standard on evidentiary rulings. We're going to talk about these in a minute. The cons to filing or engaging in summary judgment adjudication or litigation is delay. As you will see, delay really has a lot to do with the notice period that is required in summary adjudication. And one other thing is that probate cases are not subject to the ordinary civil delay reduction rules. And so while you are very likely to have your motion heard and not have to really file it and have it heard under a strict deadline, it will very likely delay the time that your case will eventually get tried should your motion for summary judgment get denied. As I mentioned, there's a very long notice period for these motions and could end up being longer. We'll talk about that in a minute. The summary judgment statute is highly technical and complex, and you are going to be required to apply the statute when you file your motion. Summary judgment is expensive. You would be educating your opponent. You have a very high likelihood of denial of summary judgment, and that's connected with the judicial policy to try cases. And then if you're granted summary judgment and the judgment ends up being appealed, you have a de novo review on the merits of the summary judgment order. You'll notice that a lot of these pros and cons are the same that you would need to consider when you're talking about filing a demur and motion for judgment on the pleadings at the outset of the case. A lot of those same considerations you'd see in determining whether or not to file a motion for summary judgment. So what kinds of cases are really amenable, at least in the probate and trust field, to summary judgment? So if you are representing a respondent with a complete defense, absolutely, that is amenable to summary judgment, especially if it's a fairly easy issue to prove. Now, that you need to compare that with whether or not you have a factual issue as a matter of law that might be disclosed in the petition itself, which would be amenable more to a demur or motion for judgment on the pleadings. When we're talking about summary judgment, we're talking about a situation, for example, where a statute of limitations might have expired after the service of a trustee's notification under section 16061.7. That would be a great situation where you could file a summary judgment motion. Will and trust contests, not usually. You don't usually would consider filing a summary judgment motion on will and trust contest. However, I'm citing to you a case here. I want to be absolutely 100% clear on this. This is an unpublished case. It is out of the 3rd District Court of Appeal. Here's why I'm giving this to you for a couple of reasons. Number one, if you read this case, you will recognize one of the attorneys named in this opinion. I am not at all afraid of shameless self-promotion. I was involved in this case. I argued this appeal. Unfortunately, it wasn't published, but what can you do? But this is an appeal on a summary judgment on a garden variety will contest. Again, there are precious few published opinions that talk about summary judgments in the context of a will contest. This I'm giving to you as an example of what one of those might look like. It's, again, garden variety. A will that was challenged for lack of capacity, undue influence, failure to execute according to law. There are a couple other issues, post-judgment issues that came up in the opinion, but I'm giving this to you as sort of an example of what a court that squarely dealt with a will contest and how it would review a case where summary judgment was granted. Breach of trust case, maybe. It sort of depends on what the nature of the breach of trust was. If it's misappropriation, it might be easy. You can just present bank accounts or things of that nature that could trace misappropriated funds to the wrongdoing trustee. A case involving a battle of the experts, no, especially if your experts are opining on issues that are dispositive of the case or might fill in the gap of a mandatory element of a cause of action. Where you have battles of the experts that do not agree on their opinion, that is a garden variety triable issue of material fact that would have to be tried. Elder abuse cases, maybe, depends on the nature of the elder abuse. If we're talking about theft of money, again, maybe bank statements would help address those issues. Otherwise, you would need to evaluate it on its own merits. Probate Code Section 850 petitions, definitely. When you're talking about, especially when we're talking about title to property, and you have to deal with presumptions of title based on the deed, where title presumption can only be rebutted by clear and convincing evidence. That might be a case where you'd consider filing a motion for summary judgment. Accounting disputes, again, maybe. It depends on on how complex the accounting disputes are and whether or not you're able to gather up enough evidence to make a real clear case that summary judgment ought to be granted. A couple of quick definitions. These should be all very familiar to you. Summary judgment is where an action as a whole lacks merit or there is no defense cause of action. Summary adjudication is where the cause of action lacks merit or one or more claims for damages has no merit to a putative damages claim, no affirmative defense to a cause of action, no merit to an affirmative defense, or one or more respondents owed and or did not owe a duty to the petitioner. So when you are dealing with a petition where you have multiple causes of action, the way you want to approach filing a summary judgment motion is to attack each cause of action individually and deal with each one as its own motion for summary adjudication. If in the end the court agrees with you on each motion for summary adjudication and there's no causes of action left, that means you're going to be awarded summary judgment. And so that's how that's the relationship between summary judgment and summary adjudication. In federal practice, I've heard the term partial summary judgment used as a substitute for summary adjudication. That's another way to conceptualize the relationship between the two kinds of motion. In filing a motion, you may not seek summary adjudication on an issue within a cause of action except by stipulation in court order. So for example, you might have an issue of whether a party was in fact a fiduciary or a de facto trustee. The resolution of that issue within the cause of action might help in convincing parties to settle or at least negotiate the case to a possible settlement. In that kind of case, you might be required to file an application with the court in order to convince the court to adjudicate that particular issue within a cause of action. Summary adjudication may be made by itself or in the alternative to summary judgment. In multi-cause of action petitions, if you are seeking summary judgment, my recommendation is to always seek summary adjudication in the alternative. We'll talk about why in a little bit. After the hearing, assuming summary judgment is granted, the result of a summary judgment is a final appealable judgment. A grant of summary adjudication, on the other hand, is a non-appealable interlocutory order. We will talk about the reasons for that in just a moment. Moving on to procedural rules. The big caution here is you must follow the procedural rules to the letter.
It's a trap.
And I've given you the Bentley case, which says a failure to comply with any one of Section 437C's requirements is likely to be fatal to the offending party. So it is extremely important that you follow these procedural rules to the letter. It will give if you fail to, it gives the court a reason to rule against you. And we all want to avoid doing that. So talking about the procedural rules, timing. Summary judgment motions may not be filed within the first 60 days of the filing of the subject petition. And that means for respondents, you may file a summary judgment motion on day 61. The rule is that you can file a summary judgment motion against someone not later than 60 days after the general appearance of the person against whom you are filing. Petitioners have made a general appearance by filing their petition. So respondents can file on day 61 without even having responded to the petition. Now, I would think that that would be somewhat difficult to do. You might consider instead filing a demurrer motion to strike if it's that clear. But again, the facts really dictate how you would approach that. And we talked earlier about that the notice period on summary judgment motions is longer than ordinary law and motion matters. You must file your motion at least 75 days before the hearing. We are not using the 1695 rule that we've been talking about in the series up till now. We are talking about calendar days, not court days. That is very important. Everything in summary judgment in terms of notice and filing deadlines is based on calendar days, not court days. If you file and serve, if you are going to serve by mail in California, that 75 days is extended by 5 days. If it's served electronically, it's extended by 2 court days. You may not file your moving papers late. If you are dealing with a court that allows you to reserve hearing dates, make sure you file your papers timely. If you don't, the court lacks the jurisdiction to shorten notice unless you get a stipulation from the other side. Just as a side note, the unpublished decision that I gave you, that I cited to you, there was a mix-up on our part in filing our summary judgment motion. Opposing counsel didn't know this rule, and he stipulated to shortening notice. So I was very lucky, admittedly, very lucky, but keep this in mind. Also, if you are filing, it is your responsibility to ensure that notice is sufficient. So if you are going to file in a court that does not pre-reserve hearing dates, it is your responsibility to ensure that the clerk assigns you a date that gives you sufficient notice. If the clerk messes that up, it is your responsibility. It is not the court's responsibility. So please, please, please make sure you're getting sufficient notice before you serve your motion. Oppositions are due 14 calendar days before the hearing, and like other motions, service must be reasonably calculated to be received by the opposing party the next business day. And the reply is 5 calendar days before the hearing. Obviously, as with everything else, replies are optional. And because replies are optional, the court may refuse to consider your reply if it is filed late.
I have a very bad feeling about this.
Also, the last timing issue is that your motion must be heard not later than 30 days prior to the first day of trial, except by court order for good cause. Again, in probate, this usually isn't a problem because the court doesn't, most probate departments don't set trial, excuse me, don't set trial until all discovery is concluded, and probate departments are generally not subject to the trial delayed reduction program. And so you don't usually have this issue. You'll usually get your summary judgments heard and decided before your trial date is set, but you want to keep this in mind in terms of a timing issue. Okay, so you're ready to file. What papers do you need to file? Your notice is required, notice of motion, just like any other motion. If you are moving for summary judgment in the alternative, the notice must say so. And the reason is very, very important. The court may not construe a motion for summary judgment as a motion for summary adjudication if the notice does not request that relief. So as I said earlier, if you're going to move for summary judgment on a multi-cause of action case, always, always, always move for summary adjudication in the alternative. In filing your notice, you must identify all of the documents upon which the motion is based. You're also required to file a memorandum of points and authorities. I've set out the length of the points and authorities. Note that this is 20 pages, not 15, as is allowed for summary or for other types of law and motion matters. If your points and authorities is longer than 10 pages, you're required to include a table of contents and table of authorities. I have never seen a court deny a motion, though, for failing to include a table of contents and table of authorities. I will tell you that I have seen very angry and upset judges that don't have the table of contents and table of authorities. I have seen judges continue motions so that table of contents and table of authorities can be included. When you're filing your points and authorities, when you're drafting it, for all that is good and holy, please discuss the rules under CCP 437C in the Aguilar case that you are trying to apply. It really, really helps the court to focus on the appropriate ground that you're using for your motion. And frankly, it also gives you credibility that you know how to navigate around this complex statute. So please, 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 I have seen motions that have not cited to CCP 437C or any summary, any case that interprets it. That's a bad idea. Always tell the court what you're trying to do in terms of complying with the summary judgment statute. The next document that is required is the separate statement of disputed material facts in support of the summary judgment. This is under Rule of Court 3.1350. This is the single most important document in your motion. And so it's incredibly important that you draft it carefully and that you do it right. This must be a separate document from the rest of your moving papers. Do not, let me recommend, by the way, especially for summary judgment, it is, in my opinion, better practice, not required, but better practice to file your documents in support or in opposition to a motion for summary judgment separately. In other words, a separate notice, separate from your points and authorities, separate from your evidence, and definitely separate from your separate statement. Again, the rule requires that it be a separate document. You must provide an electronic version of your separate statement to your opponent within 3 days of your opponent's request. And you'll see it's because the opponent is required to respond to it verbatim. Now, the purpose of the separate statement is to save the trial judge from having to review all of the evidentiary materials. Now, this is a citation from a case. It is absolutely true, but I will tell you that judges do review the evidence. It is more a matter of, you know, that the evidence is consistent with the statement of material fact that is presented in the separate statement. We'll talk about the formatting and how that works in just a moment. By the way, the text of Rule 3.1350 gives you specific examples of how the separate statement should look. And so if you're not familiar with it, be very, very mindful of complying with those rules. And I'm going to give you a sample form in just a few minutes so that you can see how the separate statement looks. In drafting your separate statement, keep in mind the golden rule. If it's not in the separate statement, your evidence simply does not exist. The court will not consider your evidence in support of your summary judgment motion if it is not in your separate statement. This is a harsh rule, but it is absolutely critical. If you have evidence in support, it must be in your separate statement. And so be very, very mindful of that.
It's a trap!
You're going to hear that a lot. Sorry. Your evidence is also required. As with all law and motion matters, your evidence must be admissible, and they would include declarations. Now, that declarations from counsel are allowed, but you should really use them sparingly and really only to authenticate documents such as deposition transcripts, pleadings, or discovery documents. Summary judgment and summary adjudication motions are effectively mini trials. And so you should approach the presentation of your evidence by declaration in the same manner as though you were presenting evidence at trial. So if you are the attorney that is presenting a declaration and it's more than really just authenticating documents, you become exposed to being deposed yourself. And that causes an obvious and really uncomfortable ethical problem. So unless there's a really desperate need for you to include evidence to give more than authentication of documents, really try and avoid filing declarations on your own. You would include expert witness declarations. Let me back up for a second. We're talking about declarations. Also, you want to remember from episode 1 that declarations on information and belief are inadmissible for lack of personal knowledge. You would also, if necessary, you would include expert witness declarations. And I'm going to mention People v. Sanchez in a moment, but again, you are treating this as a mini trial. So if you're going to include an expert witness declaration, the expert witness must be qualified in the declaration. You must make sure that there are sufficient facts to communicate to the court that the expert is qualified to testify as a witness, as an expert witness, and then include the expert witness opinion. Now, People v. Sanchez, just a quick aside here. For those of you that are not familiar, People v. Sanchez is probably one of the most important cases concerning expert witness testimony that we have. And if you're not familiar with it, get it, read it, be familiar with it if you use expert witnesses at all. And what People v. Sanchez basically says is that where an expert witness testifies as to matters that are not case specific, in other words, any data or treatises or any knowledge that the expert witness might be relying upon to form their opinion, that the underlying evidence on non-case specific matters do not need to be itself admissible. However, case specific evidence, for example, medical records of a decedent, for example, financial statements, those kinds of case-specific matters upon which the expert witness relies must itself be admissible. And so as long as you follow the People v. Sanchez rule with your expert witness declarations, then you're going to be fine. Otherwise, you expose yourself to hearsay objections, and we will talk about the badness, how important evidentiary objections are when we talk about objections to the motion. But it is critically important if you use expert witness declarations that you follow People v. Sanchez as well. Also, another thing to keep in mind with regard to expert witness declarations, as I hope you all know, when you engage an expert witness that you haven't disclosed, generally speaking, that expert witness and their opinions are covered under the attorney work product doctrine. It is only until the expert witness is disclosed that the expert witness is subject to the ordinary discovery rules under CCP 2034. I think if I've got that right, under the expert witness rules. However, if you decide to use an expert witness in a motion for summary judgment, that work product privilege is lost. It is waived, and it exposes your expert witness to being deposed sooner than you otherwise would have to, which is usually right up against trial. So keep that in mind when you are deciding to include an expert witness declaration in a motion for summary judgment. So you also want to use deposition transcripts. Again, like we talked about before, you will only want to use certified copies of transcripts. You also only want to use excerpts only. Generally speaking, all excerpts from the same witness should be presented as a single exhibit with relevant excerpts highlighted. And please, 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 on motions for summary judgment and motions in general, never provide the full transcript. It's a waste of the court's time, and it just doesn't make a whole lot of sense to send in the entire transcript. Also, written discovery responses, the same rule, only provide the relevant excerpts. For written discovery responses, you include the verification. That's critically important. And also subpoenaed documents you'll want to include in the motion. If you're going to include subpoenaed documents, you must include the custodian of records declaration in order to demonstrate the business records exception to the hearsay rule. I see a question here in the Q&A.
Yes, Mark, quick question. Is it necessary to include the depot page showing the person was sworn in and the page showing it is signed by the court reporter?
You will need to provide the certification. So that would cover the page showing that it was signed by the court reporter. My practice always was to include the cover page of the deposition transcript, the excerpt, and the certification page. If you feel more comfortable including that the witness was sworn in, you certainly could. I don't know of any rule that would require that be included unless there's some issue with the oath. The assumption is that by virtue of the certification, the deposition was done under oath and pursuant to the relevant rules under the Code of Civil Procedure. So I wouldn't, but there's certainly nothing wrong with doing it. If nothing else, it prevents an argument from the other side that the person wasn't under oath. I mean, that would seem to be a silly argument to make in a deposition transcript. But if it came to it, you would prevent that argument from being made. More evidence, you can include a request for judicial notice under Section 4, Evidence Code Section 452. One thing that is absolutely critical is that in summary judgments, you may not rely on your own pleadings in support, even if they are verified. And so if you need to include facts that are set forth in your own petition or your objection, draft them into a declaration for your client. Don't rely on your own pleadings. Keep them out. Now, on the flip side, you can rely on the other side's pleadings in support or in opposition to the motion as a judicial admission. That's perfectly fine. The rule is that you cannot rely on your own pleadings.
Mark,
yes.
Sorry, Mark, one other question. What if the expert is basing their opinion on hearsay contained in the medical records?
So again, it is the party who is presenting the expert witness declaration to lay the appropriate foundation that the records upon which the expert is relying is itself admissible. So for example, for subpoenaed records, you would include the custodian of records declaration in order to overcome that hearsay exception, or overcome the hearsay exception in order to establish the business records exception to the hearsay rule. Sorry. And so it is up to the proponent of the evidence to ensure that every single, so that the expert is not relying on hearsay when it's case specific evidence. And I hope I've appropriately answered that, because it's the same thing that you'd be required to do at trial. And so, for example, you know, in connection with your summary judgment motion, if the expert's going to be relying on medical records, you would either include the expert or the custodian records declaration, or separately authenticate those records as part of your motion for summary judgment. Either way would work. As long as you are overcoming that hearsay problem, you're going to be just fine. Okay. Moving on, Rule of Court 3.1110F includes something called an index of exhibits. I've never used one in summary judgments. And whether or not it's required, I candidly don't have a good sense of whether or not it's required for summary judgments. My way of thinking, because you are dealing with the evidentiary rules as though you were handling them in trial, it makes more sense to include your documents attached to declarations that actually authenticate them. An index of exhibits doesn't do anything except say, here they are. At least in terms of being perhaps a little methodical, I would do it in that way. However, there is authority to say that you have the index of exhibits and that it's required. I just think it's a little bit cumbersome when you're having to authenticate documents that would be an index of exhibits anyway. So that's how I would handle it. Next slide. So now, papers in opposition. We've got your separate statement. The opposition is required to file a response to the moving party's separate statement. The format is in Rule 3.1350H. You really have three options on how to respond to the moving party's evidence. It's either undisputed, disputed plus evidence, in other words, reasons why you're disputing the evidence, and or evidentiary objections. We'll talk about how that looks in a minute when we look at the sample forms. One thing that is very key to think about when you're in opposition to a motion for summary judgment, and that is that if you respond undisputed to a material fact, it does not constitute a judicial admission. Remember, what we're doing here in summary judgment is determining whether or not there's a triable issue of material fact. Put differently, is a trial even necessary? And so that is a different set of standards than what you would have to do in trial. And so the statute specific or the case law specifically says that if you decide to respond to a matter as being undisputed, it cannot be used against you at trial. The other side still has to prove the underlying fact at trial if the motion is ultimately denied. Another thing that the opposition would consider filing are evidentiary objections. Is not required, but I absolutely 100% strongly recommend considering filing evidentiary objections at any possible point that you can. And this should be the first thing you should be doing if you are opposing his motion for summary judgment, is going through the evidence in support and picking out evidence that is objectionable from an evidence standpoint. Here's why. The court may not consider any evidence to which an objection has been made and sustained, and that is in CCP 437CC. So therefore, if the moving party submits a single fact in support of an element to a cause of action, and the evidence is not admissible, if the court sustains the objection, the element cannot be proved and the summary judgment motion is denied. It is a powerful, powerful tool in opposition to a summary judgment. I cannot emphasize enough how important evidentiary objections are in opposition to a motion for summary judgment. At the same time, if you do not make your objection to the evidence at the time that the motion is filed, those objections are waived. And so it is absolutely critical. We talked about it at length, expert witness testimony. If you have an expert witness declaration, you take a look to make sure that they have complied with People v. Sanchez, for example. You can make hearsay objections. You could make relevance objections under section 352 of the evidence code. Everything is at play under the evidence code. Just by way of anecdote, I had a summary judgment motion years ago where I objected to every piece of the moving party's evidence based on relevance. Every objection was sustained, and so the motion was denied because there was no evidence to support the motion. You've got to know pretty quickly that case we negotiated pretty quickly after that motion. We ended up settling. So it's again, I can't emphasize enough, at least my opinion, that evidentiary objections are really, really important. And conversely, if you're the moving party, you got to write your declarations in such a way that your evidence is not objectionable. You also have required, of course, points and authorities. You also, if you are objecting to a motion for summary judgment and have evidence to demonstrate that a material fact is disputed, you would need to provide evidence to support the assertion that it's disputed. Another document that you could use is something that has been called additional undisputed facts. This is a separate document that is in the same form as the moving party's undisputed facts. And those could be used, for example, to establish an affirmative defense in opposition to a petitioner's motion. Talk about burdens of proof and all that in a minute. That is often done to demonstrate that there are additional undisputed facts that would justify denial of the motion for summary judgment. You might recall in demurs or other pleadings motions that, if it's the first time around, a petitioner can file an amended petition in order to moot out a demur and supersede everything. There's a similar sort of procedure in summary judgment in opposition to a summary judgment, and that's a request for a continuance under CCP 437CH. The opponent can seek a continuance by ex parte application if there is evidence that is believed to be out there that would support the opposition. Now, the way you would do this is file an ex parte application for a continuance, and you must demonstrate the type of evidence that is sought, not necessarily the precise evidence that is sought, but what you're looking for that might help might support an opposition to summary judgment, and how you are going to get it, and also when you expect to receive it in discovery. The deadline to do this is before the date that the opposition is due. My recommendation, if you run into this situation, is to pick up the phone, call opposing counsel for the moving party and say, hey, I'm going to request for a continuance. I'd rather not do it ex parte. Will you stipulate? And then you do a meet and confer on that. That way you can have that as part of your ex parte application to convince the judge to grant a continuance in order to complete the discovery. Yes, so that is an available option to the opposing party. On the reply, again, the reply is entirely optional. It's a maximum of 10 pages. Don't file it late. If you do, the court's probably going to disregard it, especially since it's due less than a week before your hearing. There is no separate statement allowed except to respond to the opposition separate statement. And so you may not add to your originally filed separate statement. You can only respond to what the opposing party has filed. And you are also allowed to object to opposition, any evidence that the opposition may have put forth in opposition to the motion. Now, one thing that I think I neglected to mention way back in episode 1 when we were talking about general rules for motions is that you are not allowed to include what we call new matter in the reply papers. Any matter that could have been included in your moving part papers is not allowed to be submitted in support of your reply papers unless you are using it solely for the purpose of perhaps impeaching or creating a doubt in the evidence that is submitted by the opposing party. So that is a very important limitation, not in just motion for summary judgment, but also motions in general. All right, drafting the motion. When you're drafting the motion, you need to keep a lot of concepts in mind. And the first is, starting way 30,000 feet in the air, is you have to consider the pleadings in the case. Pleadings frame the issues. In other words, the pleadings tell you what is material. What you need to do is really think about the elements of each cause of action in affirmative defense. And if you're filing, you need to ensure and keep in mind what evidence you can give to the judge that supports each element to the cause of action or affirmative defense. Pleadings do not limit the evidence on summary judgments like a demur does. It only tells you what the issues are. Very important is that a moving party may not seek summary judgment or summary adjudication on issues that are not raised by the pleadings. However, on the other side, on the opposition, the failure to object to seeking summary judgment on a non-pleaded issue, it does constitute a waiver. So if you're on the other side, if you're opposing, you need to be very careful and keep this in mind. That's an opportunity for you to object and justify a denial of the motion. Okay, so burdens of proof. When you're moving, you are really kind of dealing with two burdens of proof at the same time. Your burden of proof on the motion and the burden of proof on your cause of action. Your burden of proof on the motion is to demonstrate no triable issue of material fact and that the moving party is entitled to judgment as a matter of law. Again, you're going to see this all over the place. That is the key language. The moving party always carries the burden of persuasion that no triable issue exists. This is going to be the first time you see Aguilar. These are the Aguilar rules. It's a very important set of rules that we're going to be talking about here. What we're talking about is the beginning of a shifting burdens analysis. The moving party carries the initial burden of persuasion. Now, the fact that the motion is not opposed does not change the requirement that the moving party must meet that initial burden. In other words, if there's no opposition, if the court finds that the moving party does not demonstrate a triable issue of material fact, the court must deny the motion. It is not a concession that the motion has merit. Now, moving on, the next another burden really depends on who's filing the motion, whether it's petitioners or respondents. And this is under 437C subdivision P. If you are a petitioner moving for summary judgment or summary adjudication, your burden is to make a demonstrate prima facie evidence of proof of each element of the cause of action. Now, keep in mind, we are really focusing on causes of action right now. And so if you have a cause of action, you need to demonstrate proof of each element. You are not required to negate affirmative defenses. Frankly, if I'm a petitioner, I'm going to anticipate them where I can, but you don't want to give away too much in your moving papers because you can always respond to evidence in support of an affirmative defense in your reply papers. However, if you are the petitioner moving for summary judgment, if your petition anticipates affirmative defenses and pleads facts to avoid them, those facts are material and must be refuted in the moving papers. And so you remove that rule. You don't have to negate affirmative defenses if they're in your pleadings. So that's a very important rule. If you are a petitioner moving. Here's the second layer of your burden. Where your burden at trial, if you're a petitioner, is a preponderance of the evidence, your burden is a preponderance of the evidence of motion for summary judgment or summary adjudication. If you meet a preponderance of the evidence that there's a triable issue of material fact, you've met your initial burden. Same thing if your burden at trial is clear and convincing. You must show clear and convincing evidence of each element of the cause of action if that's your burden in order to meet the burden of a triable issue of material fact. Until the moving party has met that initial burden, the opposing party has no evidentiary burden. And so therefore, if the argument is in opposition, hey, you haven't met your initial burden, that can be the end of it. You don't have to present any evidence in opposition, and the court can accept that argument. And so it's a really, really high burden for the petitioner to meet in order to be successful on summary judgment. Once the burden is met by the petitioner, the burden then shifts to the respondent to meet its burden of production to make a prima facie showing that a triable issue of material fact exists. This is where we get to whether or not in the separate statement you have disputed or undisputed facts. And this is why that document, that single document, is so critically important. That's where the court's going to analyze whether or not there is in fact a disputed material fact. Okay, so we've talked about petitioners moving. Now we're going to talk about respondents moving for summary judgment or summary adjudication. Respondents have two ways to meet their burden. Either there is a complete defense to the cause of action, or one or more elements of the cause of action cannot be established. That second one is often called the tried and true way of moving for summary judgment. Moving for demonstrating a complete defense, pretty relatively simple. You must affirmatively prove that each element of or defense, let me back up. Must affirmatively prove each element of the defense. And so that's very similar to the petitioner's burden of proof on the motion for summary judgment. It is not, you may not meet your burden by showing an absence of evidence on the petitioner's part or an ability to disprove the affirmative defense. Alternatively, a respondent can move, try to show that an essential element of a cause of action cannot be established. And what that means is that there is evidence that negates as a matter of law an essential element of a cause of action. So for example, when we're talking about this, in the Fuller case that we talked about, that I gave you the unpublished case at the beginning, the will contestant in that case alleged that the contested will was not executed according to law. And so in opposition, my client was able to establish that the will was in fact properly witnessed and that the witnesses actually saw the decedent execute the will in their presence. That's all we needed to show. The contestant claimed that the will was not properly dated, and that claim was eliminated by an evidentiary objection, claiming that that evidence was irrelevant because the will does not need to be dated in order to be valid. And so that's how you would approach an opposition to a relatively simple set of elements to a cause of action, claiming that a will, for example, was improperly executed. The other way to show that an element cannot be established is by showing evidence that the petitioner does not have and cannot reasonably obtain evidence to support the essential element. This is extremely difficult and time-consuming. What does cannot be established mean? It means that you present evidence that the petitioner does not have and cannot reasonably obtain evidence to support the element. And it's not enough simply to show that the petitioner has no evidence. You must show that the petitioner cannot reasonably obtain evidence. How do you do that? you present petitioner's admissions, deposition testimony, factually devoid discovery. So for deposition transcripts, deposition testimony showing a refusal to answer a question is not sufficient to show that the element can't be established. If you have a situation where the deponent refuses to answer, you must move to compel first and get an answer. Saying to the court, well, they just refuse to answer, so therefore they don't have evidence. No, you've got to go through the motion to compel process before you can meet that burden. As far as written discovery is concerned, this is where contention interrogatories is hugely important. State all facts that support your contention at paragraph blah, that blah. And if you get factually devoid discovery from that, you've gone through the meet and confer process, you've gone through the motion to compel process, you followed up with deposition testimony, what's your evidence to support this fact? Then you've got perhaps sufficient evidence to show, look, this person has made this allegation, but they can't support it. That's what really this comes down to, that they have to meet their burden to prove this particular essential element, and they simply can't do it. It is a high burden, and it takes a lot of evidence to make that claim. Really important in opposition, you may not attack the credibility of the moving party's evidence. Credibility is absolutely irrelevant in summary judgment litigation. All the court is concerned about are there facts that need to be tried? We don't care whether or not we believe it or not. That's for, witness testimony at trial. All we care about is, are there facts out there that could lead a trier of fact to determine one way or the other. Reasonable inferences may be sufficient to create a triable issue of material fact. And so if you have an inference that could support your opposition, then that could be sufficient to justify denial of summary judgment. Evidentiary presumptions may affect the burden of production. So for example, if we talk about an 850 petition over the ownership of real property, for example, we have a presumption that title to the property as indicated on a recorded deed is presumed to be correct unless rebutted by clear and convincing evidence. That may affect the burden of production and would need to be argued in your motion in order to demonstrate to the court either that there is or is not a triable issue. Ruling on the motion. The court goes through a three-pronged analysis. The first is, what are the issues framed by the pleadings? The second is, how has the moving party met its burden of production to show a triable issue? If the answer to that question is yes, you move on. If no, the motion's denied. If the burden is met, has the opposing party met its burden to produce evidence showing the existence of a triable issue? If the answer is yes, the motion is denied. If no, the motion is granted. Court must consider all of the evidence and all of the inferences reasonably drawn from the evidence. And when we say all of the evidence, remember I said earlier that if it's not included in the separate statement, it does not exist. This is where the court might feel compelled to move away from that rule. If the evidence is in your motion, or if it's judicially noticeable, the court is free to consider it. Although you really don't want to pin your hopes on the court considering something that might be buried in a fairly large motion. In ruling, the court must view the evidence in the light most favorable to the non-moving party. This is why summary judgment motions are frequently denied, because all of the presumptions and all of the evidence is construed in favor of the opposing party. The court must not weigh the evidence. Again, we don't care about who's more convincing or not. we're doing everything on declarations here. And so the court does not have at its disposal a live witness to determine whether, to decide whether or not they believe one witness or another. The court just simply says, are there facts in dispute? We're going to try it. That's the end of the analysis. Conflicting inferences, as I mentioned earlier, can create a triable issue of material fact. We talked about the importance of evidentiary objections, but if there are any objections that are not ruled upon, those objections are preserved for appeal. My recommendation when it comes to evidentiary objections is you always ask for rulings. The court doesn't have to make rulings on all of the evidentiary objections, so long as the court finds that an evidentiary ruling would not affect the outcome of the motion. But it's always a good idea to get on the record a request to make rulings on your evidentiary objections. Although that is not required. That used to be the rule, that you were required to ask for rulings. That is no longer the rule. Uncontroverted declarations must be accepted as true. Again, all we care about are facts, not weighing the evidence or anything like that. And conversely, declarations that are controverted will likely create a triable issue of material fact. Now, the court does have authority to grant summary judgment or summary adjudication on grounds not raised in the moving papers. Now, I want to be very clear about this. The court has the authority to grant on grounds not raised in the moving papers, but does not have the authority to grant summary judgment on issues not raised in the pleadings. That is a very technical and subtle distinction, but it is important. So, for example, if there is an affirmative defense raised by a moving party on some whatever ground it is, but the court finds instead that the that summary judgment could be granted on statute of limitations grounds, for example, the court does have discretion to grant on that ground. However, the court, before doing that, must give the opposing party an opportunity to be heard on that issue before the court grants the motion. All right, we've been going through the PowerPoint for a while. We're going to look at some sample forms now. I'm going to take a little bit and show you what some of the documents that might be filed in connection with a summary judgment motion might look like. We've got a motion here filed by Ben Solo, the proponent of the Darth Vader Trust, for summary judgment and alternatively summary adjudication on Luke Skywalker's petition to invalidate the Darth Vader Trust. As you can see here, the first paragraph is the paragraph seeking to obtain a summary judgment order, and it gives the ground that the petition has no merit, that there is no triable issue of material fact, and respondent is entitled to judgment in his favor as a matter of law. That is all you need. You don't really need to go into much more detail than that. However, if you want to include, for example, that the petition, it was filed after the statute of limitations or anything like that, that is perfectly fine. You can do that. As you can see here, continuing on, the next paragraph is the alternative request for summary adjudication. My preference, and I think the better practice, is I have a separate paragraph for each cause of action upon which I am seeking summary adjudication. Again, if you have multiple causes of action, you should always seek a summary adjudication in the alternative. And you can see how I've got this all laid out. And the last paragraph here describes all of the documents upon which the motion is based. And so as we talked about before, these are required. What we've got here next is the separate statement. This is the most important document in summary judgment litigation. This is the moving party's separate statement. As you can see, the right column is blank. That is for the opposing party to fill in their response. And so, as we talked about before, this electronically has to be sent within 3 days, and that's why you have that right column blank. The left column is the moving party's undisputed material facts. You could see here you've got issue 1. This is the summary judgment portion. It is arguing that the petition was filed after the statute of limitations has expired pursuant to probate code section 16061.8. And we have here very specific facts. You've got the trust, you've got that Emperor Palpatine's name is the successor trustee, and so on and so forth. And then the main fact here is number 4, that the trustee's notification was sent to Luke Skywalker on December 15, 2073. And then the date that the petition was filed, having been filed more than 120 days after the trustee's notification was filed. That very likely would meet the moving party's burden of proof on a motion for summary judgment. Okay. Issue 2, this is an example of how you would set out your separate statement on a cause of action. We talk about requisite mental capacity to execute the Darth Vader revocable trust. And in this example, we are choosing to try and move that the petitioner does not have evidence and cannot reasonably produce evidence to support an essential element of the cause of action. My preference in drafting is to, even if you're repeating facts that are set forth earlier in the separate statement, you start over, you go very methodically. You really want to tell the story of the cause of action and why there are material facts. There are no material facts that need to be tried. So we're talking about lack of capacity. Look at number 9. At the moment that Vader executed the trust, he knew who his children were. You've got the declaration of Darth Plagueis at paragraph 4. Darth Plagueis being the drafting attorney who actually witnessed and was present at the time that Vader executed the trust. Then we have number 10. This is where we are trying to convince the court that Luke Skywalker does not have evidence to support that Darth Vader did not know who his children were. And so we've got the petition, citing to the petition, making that allegation, the Darth Maul declaration, which would authenticate Luke Skywalker's response to special interrogatory number 4. Again, all that Darth Maul, counsel for the moving party, is doing is authenticating documents. And so you're really listing out in detail all of the evidence that supports the fact that Luke Skywalker does not have evidence to support that Darth Vader did not know who his children were at the time that he executed the trust. Okay. And so you want to be very, very methodical. And when you're talking about the facts, you are describing the facts and then giving the evidence that support that fact. So you're going element by element. It is incredibly important to go element by element, cause of action by cause of action. I lost a motion for summary judgment years ago because I tried to convince the court that the petition, that summary judgment should have been granted because the petition lacked merit, but I did not go cause of action by cause of action because the elements were different for each cause of action. I should have won that motion, but because I didn't do it cause of action by cause of action, my motion got denied. Don't make that mistake. For every cause of action that you're dealing with, deal with it separately. And so we got issue 3, Darth Vader was not unduly influenced into executing the Darth Vader revocable trust. Here, we don't have evidence to show that Luke Skywalker cannot produce evidence to support his claim, so very likely that burden would not be met. Next, we're going to go to the opposition. I know you all know how to do points and authorities and declarations and requests for judicial notice. I'm not going to give you samples for that because I know you all know how to do that. But these are unique to summary judgment litigation. So here is the response, Luke Skywalker's response to the separate statement. Number one, Darth Vader executed the Darth Vader revocable trust. There is no reason to dispute this. It's an undisputed fact, assuming that it's all there in the evidence. It's not a judicial admission. You can move on and claim that it is undisputed and really focus on what is actually disputed. You've got undisputed here again. Number four, Schmuck sent the trustee notification pursuant to probate code on December 15, 2023. We've got here disputed. The proof of service, and in support, the fact is the proof of service states that the trustee's notification was on December 15, 2073, but the postmark on the envelope that carried the trustee's notification said that it was mailed on December 20th. So we don't care whether or not that's true, and assuming that the and/or declaration actually supports that, we don't care about whether or not that's true. It creates a triable issue. The motion as to that affirmative defense would likely be denied. Okay, and here's another lesson from this: keep the envelopes that you get your mail in, because then if things are dependent on mailing, you then have the postmark and can possibly help you. Issue two, requisite mental capacity to execute the Darth Vader revocable trust. So you've got, at the moment that Vader executed the trust, and he knew who his children were. You've got disputed. Darth Plagueis is a Dark Lord of the Sith with knowledge and ability to manipulate the minds of his clients. And so in support of that, you've got the Darth Plagueis deposition, how he was somehow able to get Darth Plagueis to admit that he can manipulate the minds of his clients. I don't know how his lawyer lets him do that, but whatever. And so you put in every fact that would support that this number 9 is disputed. Don't care if it's true. If it's a disputed fact, the court will deny. Luke Skywalker does not have, number 10, Luke Skywalker does not have evidence to support his allegation in the petition that Vader did not know the natural objects of his bounty. This is disputed. We have an expert witness. Your expert witness is Mace Windu, who opines that Vader was not likely to have sufficient memory to know who his families were. And because that is the entire subject of the Mace Windu Declaration, you cite it as the Windu Declaration, and the court can review that and determine on its own whether or not it is sufficient to support a triable issue of material fact. So importantly, let's go to number 15. Down here, Vader was the one who supplied by email all of the information that was inserted into the trust distribution provisions. Darth Plagueis Declaration, that is cited. Instead of disputed or undisputed, we have an evidentiary objection. If you have an evidentiary objection that would eliminate this fact, you cite it in opposition to the motion, and then the court can refer to it. Hey, Sarah, how are we doing on time?
Good. You have about 15 more minutes.
Thank you. And so you've really got the same sort of issues here on the separate statement, response to the separate statement. Again, you could see why this is so important. This is what the court's going to look at first and try and determine whether or not, and really focus on whether or not the disputed matters are actually disputed, and determine whether or not a trial is necessary on a particular cause of action. So drafting this is really, really, really important. The last sample document here is the evidentiary objections. This is one of the prescribed forms that is set forth in the rule of court. It's pretty straightforward. If you are going to be objecting to an entire declaration, for example, you can say material objected to the declaration of Mace Windu in its entirety. So, and the objection would be improper expert opinion and hearsay. The court will make rulings on that. Now, the rule of court does require that you submit also a proposed written order if you file these objections. And really all you would add is a line down underneath objection number 1 that says court's ruling, and the court can just simply check off sustained or overruled. But what I've seen in practice is that when the court makes a written ruling in the summary judgment motion, they will incorporate those evidentiary rulings into the order itself. I don't know that I've ever seen a court use the proposed order on the evidentiary objections. To me, it's a little bit cumbersome, but the rule of court requires it. So if you're going to make evidentiary objections, you should submit proposed orders on ruling. Number 2, you got a People v. Sanchez objection here on the Mace Windu declaration. If you are objecting only to certain portions of a declaration, you must quote it verbatim. And so, as you can see, there's a quote of opinion based on medical records. You would quote that and include it verbatim and set forth your objection. Sometimes, now these are very simple objections. Sometimes your objection might need a little bit of extra explanation, and there's nothing wrong with including that. You're making an argument in support of an evidentiary objection. Just make it brief. If the court needs more information from you, you can elicit it at the hearing. But these are intended to be quick and straightforward. You always include authority for your evidentiary objection. But again, it's incredibly important if there are evidentiary objections, you raise them in this way. Okay, so let's go back to the, hey, Sarah, can you see the PowerPoint? Are we on ruling on the motion?
Yes.
Okay, thank you. All right. So you've gone through your motion hearing and assume summary judgment is granted. In the order, the court must state the reasons in the order and cite to the evidence leading to the conclusion that there is no triable issue of material fact. The summary judgment order itself is not appealable. It is still an interlocutory appeal. So if you appeal the summary judgment order, it is technically premature. But that is often cured when the judgment is ultimately entered. The appeal on the judgment in the real world really turns into an argument over the propriety of the summary judgment order. So the point of bringing this up is you don't need to appeal the summary judgment order as soon as it is entered. You need to wait until the actual judgment is entered, then you can file your appeal. Typically, the prevailing party on a granted summary judgment order asks the court on an ex parte basis to enter the judgment consistent with the order. The court can also direct the prevailing party in the order to prepare the judgment. It's really a matter of individual judge's preference. And so, or sometimes the court will enter judgment at the same time as entering the summary judgment order. That I've seen happen as well. So there's no hard and fast rule. Just know that the important thing is that judgment is entered. Motion for summary adjudication granted. The trial continues as to any remaining causes of action, and causes of action where a summary judgment is granted are deemed established at trial. And so you don't need to litigate those issues that are where summary adjudication has been granted. And so you continue fighting like these guys. What do you do after your hearing? One option is for motion for reconsideration under CCP 1008. As we talked about, in the last program. Don't do it. Not a good idea. There is too much risk, and you really need to show new or different facts, circumstances, or law. A renewal motion, however, under CCP 1008 and 437 CF2 is also based on new or different facts, circumstances, or law, but can be made more than 10 days after the order denying the summary judgment or summary adjudication motion. You can also include issues in a renewal motion that were not raised in the earlier motion. So if your motion was denied and another, for example, defense comes up to, or new facts come up that would justify a complete affirmative defense, you can file a renewal motion. Again, it's 75 days, and you have to go through the whole notice period. At that point, having a second summary judgment motion probably isn't the best idea, but at least it's available in the appropriate case. Motion for a new trial is available under CCP 659. This is after the judgment is entered. We will talk about that in detail in episode 6 in a couple of weeks. You can move for relief from the judgment and enter new or different, motion for relief from the order under CCP 473B. That is done before the entry of the judgment. We talked about that in episode 3 for inadvertent surprise or excusable neglect. Another post-hearing procedure is going to be the memorandum of costs or motion to strike your tax costs. That is done after the entry of the judgment. I caution you to take a look at Probate Code Section 1002, which gives the court the discretion to award costs after entry of judgment. It is not the automatic rule in ordinary civil litigation that the prevailing party is entitled to cost. It is the court's discretion to award costs. And so when you're moving for summary judgment, you may want to ask the court in the conclusion to award costs if summary judgment is in fact granted. We'll talk about that in more detail in episode 6. I see that there is another question. I'm almost done, and I will get to that at the very end. I've got maybe just a few more slides here. You can, of course, appeal summary judgment. Like I said before, it is the de novo standard of review on the merits of the motion for summary judgment. However, it is abuse of discretion standard on evidentiary rulings. Again, super important. If you have evidentiary rulings or objections to evidence, you get them in, because those are harder to overturn on appeal than an order for summary judgment on the merits, because that is reviewed de novo. There are a couple of oddities to summary judgments that bear at least a little bit of mention. You are allowed to file cross motions for summary judgment. The fact that there might be cross motions does not necessarily mean that there's a triable issue. Each motion must be evaluated independently and without reference to the other. As a practical matter, if you are filing simultaneous cross motions, the chances are, because they are so voluminous and difficult to evaluate, the chances are after the replies are filed, you might get a continuance in order for the court to fully evaluate both motions. Again, that's not necessarily true, but I've seen that happen pretty frequently. Another oddity is a motion for summary adjudication granted prior to a jury trial. Now, granted, jury trials are generally not allowed in probate code matters. That's pursuant to Probate Code Section 825. Notable exceptions would be conservatorship appointments and terminations. Also, financial elder abuse cases may be entitled to a jury trial. In that case, if a motion for summary adjudication or summary judgment is filed, no party, witness, or the court may comment to the jury upon the grant or denial of a motion for summary judgment or summary adjudication. If a grant of summary adjudication is made, the jury is simply instructed that that cause of action is deemed established. Not for any reason, it is just deemed established, and that's the instruction that's given to the jury. Finally, the last oddity, motion for summary judgment or summary adjudication granted on grounds were not raised We talked about this briefly. The court evaluates the motion and finds no triable issue, but on grounds not raised by the moving papers. The court has two options. One is to simply deny the motion. The other is to grant, but the court must give the non-moving party notice and an opportunity to be heard on that issue, and then the court can evaluate whether or not to grant based on the non-raised issue. Now, whether or not this means that oral argument at the hearing or a continuance in order to allow the briefing and argument is unclear. The point is that the party against whom summary judgment is considered does have a right to respond and have an opportunity to be heard. Let me move over to the questions.
Are you able to see those, Mark?
I can. Oh, Doug Hausman, you crack me up. Let me take a look at the chat real quick. Oh, John Martin, I can't tell if that's John Martin or Martin Johns. Thank you. I'm so glad that the documents, that the sample forms are appreciated. Thank you for saying so. That's really very, very kind. Nathan Pastor, what if the expert, oh, I already saw that. Two-part question. If you had to live for 1 year on any planet in the Star Wars galaxy, what planet would it be and why? It would be probably Cantu Bight, because I really like to gamble. And for those of you not familiar, that's episode 8. It's like the Monte Carlo of the Star Wars universe. Anonymous attendee, upon dissolution of the Jedi Order as a whole after execution of Order 66, or a charitable gift left to them as one in one of the trust of one of the myriad Jedi who perished as a result of Order 66, what do you think would be the most likely recipient? Oh, I gotta put this over here so you all can see this. What do you think would be the most likely recipient of such a gift under the Cypre doctrine? Do you think it possible the gift would escheat to the Galactic Empire? And if so, would someone have standing to pursue a claim under the Slayer statute against the Galactic Empire as an entity? I don't know. File a motion for summary judgment. Thank you all very much. I hope you all have enjoyed yourself. I certainly have. Bonus question, if you were stuck on an island with only one Star Wars character, who would it be and why? Gosh, that's a good one. I think probably Ben Kenobi, because he seems like a pretty fun guy, and I could probably play a pretty decent chess game with him. Thank you all very much. I really enjoyed it.
Thank you, Mark.
Thank you everyone for joining us today. You will get the materials and certificates in about a week. And just a reminder, please don't share Zoom links. When you share Zoom links, we cannot give you credit. So please use individual Zoom links when you're doing this. Thank you for joining us today. And thank you, of course, to Mark Schmuck. And we'll see you all next week.
Thank you.
Bye-bye, everyone.